Welcome to the IEA's 24th webinar of 2026, which is on the law and economics of AI use, and particularly how the judiciary should approach the use of AI. We'll get into a bit of the background as to why we have that selected that topic shortly. But on behalf of IEA, I'd like to, of course, welcome all of you here. The IEA is a public policy think tank whose work is to inform decision-making in Kenya through policy innovation, research, and convening topical dialogues, such as what we have today. My name is Jacqueline Kagume, and I'll be moderating this session. So the IEA works across 6 policy areas, and our discussion today is convened by the Law and Economy Program, where I work with my colleague, Leo Kemboi, who's also going to be making part of the presentations this morning. So the brief, before I go into the background of this, so we'll have 2 main presentations, and for this we'll be joined by 2 speakers and a discussant. So the first part of the presentation will be made by Leo Kemboi, who's a program officer at the IEA. He'll share a first presentation on the economics bit of the use of AI, and then we'll have a second presentation that will be made by Mr. Seku Owino, who's General Counsel at the Nation Media Group, and he'll be sharing the legal and practical landscape perspectives. And then we'll have Mr. Kwame Owino, who will be a discussant after those presentations to just share general insights from what will emerge. So to just set the stage briefly, the brief background to our discussion today is that we all know that artificial intelligence is now increasingly present reality in most streams of work. It's already shaping how different legal systems operate across the world. Increasingly, we've seen courts, law firms, and litigants increasingly interacting with AI tools for good, and in some aspects there are some adverse consequences. And then so we've seen the use of it being deployed mostly in legal research, drafting, case management, and so on. So but as the CLE program, we felt that this has raised some fundamental questions, not just about efficiency and fairness, but about accountability and the very nature of judicial decision making. So with that in mind, we anchored the discussion today around 2 broad objectives. The first, to help us understand what AI can actually do within the judicial and legal context. So this includes its potential to improve efficiency, to reduce costs, and to enhance access to justice, particularly in systems like ours that face real constraints. We have here discussed previously the constraints of case backlogs and delays, so how it can be used positively to reduce some of those inefficiencies. Second, and perhaps more importantly, was to help us interrogate how the judiciary should approach the use of AI. So asking ourselves, what are the legal and ethical limits? What risks does it introduce, including the questions of bias, reliability, procedural fairness, and so on. So we'll be hearing from our speakers particular insights on these issues. So as I've mentioned, we are fortunate to be joined by the speakers that I've mentioned. And without further ado, I'd like to get straight into our first presentation. After the 2 presentations and the discussion thereafter, we will open this up to plenary and invite you to make some remarks as well. So if you have any questions, please note them in the chat box as we proceed, but I'll also allow you to raise your questions orally during plenary. So with that said, I'd like to invite our first speaker, Mr. Leo Kemboi, to share the first presentation. Leo, please go ahead.
We started to think about this issue seriously when courts took a policy position on the use of artificial intelligence. One is that courts, sometimes last year, judgment which referenced legislation that did not exist in Kenya, which was the Geographical Indications Act. And that was very curious, but also showed that parts of AI could go mainstream. And then subsequently, several other pleadings that were before court, and where in some occasions orders had already been issued. Then they were set aside, later set aside. And then we have to ask ourselves, given that there is this reality about artificial intelligence, what should be the question? So we've had, as Jackie has explained, there is the economics part, which is now we are going to discuss. And then secondly, there is the legal questions that the law and what you would anticipate from the Constitution. And SECU, the General Counsel for the Nation Media Group, will also be able to lay it out. So I'm going to start. So the outline is the economics of AI and judicial function. Broadly, people refer broadly to AI. We have a different typology. We are going to give the framing problem for policy, what AI can do in practice, and also the three pathways, which is like a cost-effective, a simple cost-effectiveness pathway, and then the equity questions. So as we all know, the judicial function, which the judicial function is a public good. The issue of adjudicating cases, the legal system, ensuring that the legal system runs properly, and in this case, the criminal justice system, and also the other civil part of the courts run, that entire system is a public good. There are many other inputs, including, for example, you could start from judges, advocates, the rules that put up courts, amongst other things. And if you start to think, you will also add AI as part of that list. So usually, when you have a technological a technology question, you ask if at least these four standard questions, which is one, what would be the marginal product of AI in education? What does it substitute? Now you start to begin the trade-off analysis, and at what price? Who captures the welfare gains and who bears the costs? And then what governance design realizes those gains in the model gains in practice? So when you ask yourself these four standard questions, and then if data was available, we'd be able to do a little bit of more econometric work and be able to tell and be able to define what part of AI is what gains are going to be there specifically. Then we prepared a small. So now the artificial intelligence part is artificial intelligence in two broad categories. So you could say one, the generative AI, which is what we know and what has gone mainstream now. The generative AI, which is the large language models, the LLMs from ChatGPT, Claude, and many others. Then secondly, for the generative AI, then the other exists, the non-generative AI. And the most known non-generative AI is what we call the machine learning. So those decision trees, classifiers, risk models, land splits, weights, thresholds, and many other things. So part of the thing that you see for LLMs are largely driven by tokens, which predict. This is like a mathematical model that predicts that uses probability system to generate words. And then secondly, it's been trained in a way that it's able to respond. So some of the things that the judicial applications that we see is for some of them could be judgment text, reasoning, finding of facts, and some of these things that will be machine generated. Remember that the civil procedure rules and also the other rules of the court specifically emphasize that what is a judgment? A judgment is where a judge, who is a human being, sits, listens to the case, and adjudicates. So we have to have that distinction there. Then the other things, they could summarize pleadings, they could generate case summaries, legal arguments, find specific citations. It's more of, when you think about it as a research tool, that is that's the question. The other one, non-generative AI, of which when you go online, you'd be able to see many studies that have been tested around this area, is non-generative AI. They've built models and using machine learning to be able to tell, for example, in the case of places like New York, to be able to provide a bail, an algorithm that determines bail. So, and then it could also predict recidivism, which is the aspect where someone will reoffend the law, sentence guidelines. Then it's the one big problem that you also see in courts, not just in Kenya, but globally, is the issue of active case management, which is you are able to bring case management is assigning cases to judges, tracking those cases and ensuring that that docket is someone is able to read it and hear it, and also scheduling those calendars and many other things. So case routing, classifying cases, assigning judges, estimating duration. It can also be a performance management tool. So when we speak about the AI 101 that we want most people to understand from this is that when we say artificial intelligence, we don't necessarily mean the generative AI, which emerged 3 years ago because of computing, 3 or 4 years ago because of computing. We are speaking about AI from including machine learning that has been here as far as 50 years ago, 45 years ago. The risk profile for generative is the question that it hallucinates, it invents citations, precedents, facts, and Seku is going to speak about that in more detail. You cannot audit it. It's a sampling from a probability space. So the generative AI, the way those tokens work is that it predicts, it tries to speak and mimics the way a human being would think. And be able to generate that question. Then generate those. So there is no clear rules or decision tree. And liability, the question of who is responsible now for that fabricated case law or in generated text. So that is something that is a problem, and Seku is going to speak about that. The risk profile for non-generative AI is, so even though it doesn't have hallucination, it's constrained to learn. It uses learning patterns, so it's in a fixed category list. So for example, you'd be able to see a machine learning component, for example, for transport, a queuing system, for example, and a machine learning, say in a financial market, so say in a bank, looking at, for example, customer traits or something like that. At those, it's trained to specific environment, so you'll not be able to look at that, and you cannot transpose the same. Unlike on the other side, the generative AI, which is trained on something like 100 billion tokens. So that is a little bit different. So you can audit. This one you can audit the decision tree splits. You can see the weight vectors. You can see regression coefficients. Actually, you can be able to predict the kind of reasoning that it will give. And then the biases is from history. And it's able to learn and also improve. Now, for the case of Kenya, we need to have, because this, as a public policy think tank, the IEA tries to see these questions from a policy perspective. One thing that is clear is that courts produce private goods. If you resolve a dispute, that is a private good. If you have a bigger mechanism that solves cases for the entire nation and people are able to adjudicate matters across the scope, across the entire nation, that's a public good. And that ability of stable legal rules. There is an efficiency goal here. So we have a problem with bail, for example, the way bail is offered and the way it's ad hoc. Sometimes it takes time to go through the courts for the courts to make a decision that is actually closer to. There are many other things that you could see. There's a problem with case management. There's a problem with the duration in which judgments are rendered. There is a problem with how to monitor performance. Many court users have in the past complained about how cases are assigned to specific judges. Those are policy problems. And efficiency goals can drive those is a big question from that you would expect such these digital components to be able to provide. Then AI is a technological shock. This one we are using as a model framing. Can it substitute labor and speed processes? But now we have to ask at which margins it affects. And then there's a specific problem to Kenya. Kenya has a very serious case backlog, chronic backlogs, delays, and high costs. My colleagues, Kwame and Jackie, we've studied this, and myself, we've studied this question, and we've realized that it's be very, unless something is done that is disruptive, it will be highly unlikely that those backlogs will be dealt with. So there's the question of whether can AI shift that production frontier or reduce costs, and then how can you, if those efficiency gains trade off against allocative concerns, which is in this case questions about fairness, access, equity, those things which are part of our constitution. Another problem is we were able to look at the SOJA, which is the State of Judiciary Annual Report from 22-23, and it had a very specific type of data set. Subsequently, that has not been published. But when they looked at the reasons for adjournment, they realized that 67% of all in 100 67 cases in 100 are actually because of external agency, where parties are not present already, witnesses, expert or report not ready, advocates not present ready, or prosecution not present already. And then 33% in those 100 are at that time internal agency issues, which is court being indisposed, judgment not ready, or court not sitting. And then if you take those reasons further, you could be able to see when you could be able to see even in a more detailed, if this data was more broader, collected more broader, you'd be able to see. So there's an active case management problem. So remember that the public buys time. And when the public is buying time by funding the judiciary, time is the most important decision any head of a justice system like the Chief Justice would be looking at. Time is something that you'll not be looking at. You'd be looking at other things, but the first responsibility is time. How do you assign time? How do you ensure that time is not lost? Because anytime you lose, any instance you lose time, you are losing money. And remember that our constitution has a requirement that there should be value for money. So what can AI do? AI can automate routine tasks, things like document review, research, transcription, but it has to be used. There are exceptions and riders to how this should be used. Machine learning, which is non-generative AI, can improve case flow, scheduling, prediction. The other things like the political economy questions, transfers. Remember, you all know about you know about transfers. So it enters at the various stages. And here we've looked at the judicial function alone. The users, in this case, advocates and other persons like arbitrators and others, also, given that this thing is going mainstream, the artificial intelligence going mainstream would be also users. So another thing is fixed costs. Generally, if you look at the artificial intelligence, and if you look at even all the firms that are providing AI services, there's an high development cost. It even costs more for when a government agency, in this case, like Judiciary, for example, would be to acquire an AI enterprise model. So because it has to be customized, they'll have to be service level agreements, some of those. So there'll be high development and also integration costs. Then the marginal costs. So once you build the system, it has a near zero cost per additional case. However, when the volume of cases grows, AI average costs fall. So a large jurisdiction may be able to capture bigger gains. And then the insight from this is that in the end, AI may exhibit diminishing returns beyond certain tasks that it can fully automate. And here, if you look at the requirements of the Constitution, for example, like fair trial, if you start to look at what is fair and now look at the way AI is applied, there'll be, you not necessarily find very useful uses. So, and then the economy, so to wind up in the next two slides, the first question is the three pathways. You can, if there is efficiency is high from adoption of AI and the output goes up, and meaning that in this case, the throughput, which is now the ability to resolve case resolution goes up, and it reduces case backlog and that access to justice, there's a positive case for AI use. But we also cognizant of the fact that if the marginal cost per case falls, and that leads to the throughput, is also a positive use of AI. But there is a key problem, which is the bias risk or a fairness question. And that reduces, if that AI reduces bias, reintroduces the bias risk and reduces fairness, it leads to that unfair allocation. And it has an implication for cases that could come out of, decisions that could come out of the court. And that would introduce, deal a blow to the institutional trust. And that would erode erode legitimacy and fairness and trust, because Kenyans fund this judicial function to be able to this judicial function because they want to see that fairness. And any democracy, any sort of a country that is serious about liberty, serious about the way contracts are enforced and many other things, this is a very big concern if it leads to the other way. So those are three pathways in which you could easily see that divergence. So, so in anticipation for this, the non-generative AI part, we saw a study from written from the US, written by 3 researchers, published in the American Economic Research, American Economic Research, one in 2022 and updated the same study in 2025. It's an econometric study. So when they were looking at the question about equity in the way when the machine learning is used in prediction in the question of about bail. So they realized that it does not resolve the equity question, but it's able to shift it, but give some marginal efficiency. So for example, they realized that if you train it on data, already existing data, on judicial data, and then that judicial data, from that judicial data, it will transpose the same bias to the same bias. So, and I was thinking about this because in Kenya, the right to bail is guaranteed, and unless the state applies state applies for that right to be constrained. But the way in Kenya judicial officers have understood is that the right of bail is qualified. You have to apply to be given bail. And bail or bond, and that is you see, that's a judicial bias. You have to be given bond first. You have to be given bail or bond, or unless the state now the state applies for that. So if you bring that if you train machine learning data on bail allocation, or on bail allocation, on historical data, you'd be able to, so that's a bias question that it doesn't bring up something new unless you're able to train it now on something that a new data that exists altogether. So you have to bring a different statistical design. So thank you so much.
Thank you for this invitation, and thank you, Leo, because now you've given me something from which, a springboard from which to go on to. Let's just go to slide 3. In light of what Leo has said, in thinking about artificial intelligence in the practice of law, I just wanted us to be a little simpler. So I decided to use a definition of artificial intelligence that is just hobbled together in trying to see what exactly is this as specifically as applied. So it's basically, as we understand, one, as he rightly said, it's not new. It's just that it's become more pervasive with the internet and the scope of what it can be used for. Certainly in law and in the courts, it may be a new thing for judges, but there are people who already have it. So for me, I look at it simply as a combination of software ability for performing tasks that typically require, or are hitherto generally just can be, were hitherto thought would only be done by human beings. So through human intelligence and experience. So key to this is essentially that the AI involves analysis, evaluation, and adaptation, in the sense that it can change with new facts, it can change its mind, or it can change perspectives, or it can make independent decisions based on most recent knowledge, as opposed to automation. And that's why I thought we should also use automation, because there's some link there, and particularly in the profession. So let's give the example. I think AI would go the way you can go to Amazon and you're buying books, and it will discover that maybe because you tend to buy books of a legal kind, and maybe in the last 1 year you've ordered 75% of the books you purchased were on intellectual property, then it begins to then recommend to you other books on intellectual property based on that. So basically a version of the decision to make new choices based on analysis that would otherwise not be possible. It may also realize that you probably have a bias towards books authored in America by American scholars, as opposed to, say, British or Australian or African, and then continue to make those decisions for you on your behalf. And so that whenever a new book is published, say by an American author, it will then recommend that for you. So there is artificial intelligence at work. The automation, on the other hand, is very pervasive in the legal profession, much, much more than this. And so the use of it to basically execute repetitive tasks based on rules without human intervention. One example is conducting a conflict check in a law office. This is the ethical dimension of law. So maybe you are a law firm, you have a new client, you want to check that you do not have a conflict with this setup. Basically, a conflict check is where you're saying, because the law says that you cannot act for and against the same client, you yourself need to assure yourself that, okay, in my Mombasa office, could this guy be somebody for whom we are acting in a different matter? So the thing about it is that you just go to your system and it generates for you. Once you put the client's name, it generates for you whether he's an existing client or not, and tells you the nature of matter. So that's automation. It's just, but when they are combined, then you get intelligence automation. And an example that I want to give is a case file, where in a law office, for instance, you're closing a file, you've done your work, or a client wants to close his file with you, or needs to know how much it will cost. Because if you're using timesheets and you are entering them into a system, the client can get his bill of costs or his invoice by the end of the day, okay, or even instantly. So maybe he just writes an email and gives you the number and the file, and something works out from your system and generates for him his invoice. So there's the automation. It will use the ARO there, as I said, that's the advocate's remuneration order. That's a rule, basically regulations on how lawyers charge. So it will put the rate. It knows this number of hours was spent by advocate so-and-so, who might be so-called senior counsel. His rate per hour is maybe 20,000. His assistant, who's probably a legal intern, may have spent another 5 hours. The rate per hour of a legal intern might be 1,000 shillings per hour. Then the court clerk, who then went to court to file it, may have spent 500 bob taking a cab, and was spent 2 hours. His rate might be 100 or 300 per hour, and it generates the bill immediately for him to make payment. So those are automation and artificial intelligence working together to do that for you. The next slide, please. So these are examples for which they're used, whether within the law, not just law offices, but in the profession generally, in rendering service. So you want research or comparative jurisprudence and arguments. You want to know, okay, what is the South African law on, say, public participation? And you just go on it. There are specific law research sites that can help you. Westlaw, example, case text, co-counsel. They just generate that for you and tell you, in South Africa, this and this was decided. These are what the courts have said about public participation, as an example. You can also use it for discovery. Discovery is essentially in litigation, where a requirement that, say, a case is filed and the courts require, as a way of saving time, you exchange documents. So if, say, it's a contract, where there's a dispute about it or accounts. So the parties are told, okay, why don't you exchange the documents and agree so that by the time we are coming, we have agreed documents, whatever. So you say the contract, do you have the signed contract? We agree, yes, this is the same contract. Are the invoices there? Were these the ones which have been paid or the ones that have not been paid? So you exchange those documents. It helps the court to define the issues on which there's no disagreement. If you're all agreeing that the contract that was signed last year is the same contract on which that dispute inheres, so it does that. So AI can put all those things together and generate for you the agreements or the documents that are not contentious. They say, these ones we agree. The other ones, somebody can say, these ones I don't agree because these invoices were paid or something, or they're not pending or we didn't receive them. And then a decision is made. So that's whatever. So they have something we call relativity, which helps both parties. You just put the set of documents together, it generates them and say, okay, these ones are accepted, both parties agree these documents are whatever. This one, the plaintiff is claiming they didn't receive them. So then what do we do about it? This other one, the defendant is denying that they're admissible, for example, and then you take them to the court. So it helps, particularly in commercial disputes that may have been over a long time or have huge documentation. The courts, the systems can help you distill them. Then there's the usual generation of documentation. There are books of precedents. This has always been by automation. Previously, we used to have CD-ROMs where you just put in some requests and say, generate for me a plaint based on this, an accident occurred on this particular day, the registration number is this. You put in the doctor's report and it generates a claim for personal injury, stating what has been the injury, the date of the accident, and it just generates for you a plaint or a petition or a case note or submissions just based on that. And then this is not done too much in Kenya, but it's there where you want to profile and identify counsel and judicial officers. So you might want to say, okay, based on the decisions made in Kenya, who is my best advocate if I am a defendant and I'm applying for a patent defense case, or I have a copyright or intellectual property material, or I have a merger and acquisition or anti-competition. So it will go and scour through the net if they are, or go to Kenya law reports, for example, or to the US Supreme Court and check and confirm to you and say, okay, this is the advocate who's appeared most for defendants, and this is his rate of success. You can even do it for judges. You also go and say, okay, I'm appearing before this judge. Which are the arguments on which he has been most convinced? Or how often is he in dissent if it's an empaneled court? So they generally assist with those kind of things and help you with case prediction and those kind of things. So you can see some of them, Ravel Law and Lex Machina. They don't apply in Kenya, but they can provide such service for particularly the United States. In non-contentious matters, by non-contentious matters, I mean here, these are not disputes that are in court. This is just legal work in an office like the one in which I am, or in a law firm or a department like a corporate law department or a probate department that does not go to court. It can generate documentation for you. Say a patent application, a merger and acquisition documentation. You just say, I am company in Kenya, I am acquiring a company in Zambia, this is the cost, what do I need to do? And it will generate for you and tell you, oh, you need to go to the COMESA Competition Authority, you need to go to the Zambia Registration Board, you need to do this and that in regard to that, and generate that documentation and just help you do it quickly. In a legal department, for instance, it can help us devise a legal strategy and draw KPIs for all of us, just out of an understanding of what happens in a legal department. So you have systems that can help us decide that. Contract review, yes, somebody sends a contract, it's probably 600 pages, tell him, put this, you put your contracting policy or a procurement policy against it and tell it, please raise for me what are the clauses to which I should take issue regarding this. So it will generate it for you and might tell you, oh, the contract refers to American law. Do you wish to take that? It talks about an anti-bribery principle. It talks about non-competition. It gives all those examples and then just generates it for you maybe in a 2 or 3 pager, or which then helps make a quick decision on how to go. It's called, the one I use is called Logix. And then general management and finance and budgeting and management. It can tell you which of the advocates provide the best value for money. So you put into it all the fees you pay to advocates, or it does it as it goes. It sees as you pay fee notes and all those kind of things and bills of costs, and it tells you who is the advocate who provides for you the best value for money for the work that you give them. And then, of course, comparative law advisory, cross-checking legal opinions, etc., etc. You get a case that you've never heard of, for instance, and you cross-check it, and you say, can I check this to confirm whether it's been done and it's not okay. Next slide, please. Its benefits, Leo has talked about them, but it's the simplest. Operational efficiency. Everybody knows it does for you. It can look out for a 600-page agreement, do it for you in 3 or 4 minutes, and reduce it to 20 pages. So you have just 20 pages to look at, as opposed to 600 pages, which you'd have read a whole week. This now can be work you can do in a day and get an answer. So the economic considerations and efficiency. So rather than taking it to an advocate or giving it to the advocate who would have taken a whole week reading a 600-page document, even if he uses it, he can then do it in a day. And if he's billing you on time, you generally get cheaper thing. And therefore, it's got an accuracy and quality assurance dimension to it, where some documents are sent to you, you check it against, say, your company company policies, or you check it against the decisions that have been made, and you check, is this really what it is? You can even put a document here and say, submissions, and say, please check to me against written submissions made in the UK Supreme Court, and rank them for you. They can tell you, you fall in the 75th percentile, and that it just helps you improve quality assurance. And then there's the risk management benefit of proactive compliance. You can set it up and tell it, please give me a monthly report of Kenya Gazette changes that may affect the business in which I am working. And it generates that for you once a month. Oh, in the Gazette notice, like number this and this and this, they proposed an amendment to the Copyright Act, which would affect you in this and that. So it helps with that kind of thing. And then also uniformity. If, say, you're working in a law firm or in a department where there are different people, by having this centralized system that checks it against everything, it helps them, then the quality and work standard becomes the same. Before the same. And then access to justice questions. One of the things is, as I said, because this thing is not new in a technical, it's just becoming more available. Previously, it could have been the preserve of what we would call big firms, big law firms in this country. An example, you can have categories of law firms. You have a legal practitioner who is maybe just 2 years into practice. He does not have a library. He's just running a one-man law firm. And then you have a law firm that is 120 years that has 3 or 4 floors of a library. Now, if these people were in the same case, then the equality of arms is not quite is not quite achieved, or is challenged because of the respective competencies or resources available. But now, if, for instance, this person were to be able to go to ChatGPT and do the same level of research, then there's some balance comes. Worse than even if it is a person acting pro se, representing himself, can't afford a lawyer. If he can go on to ChatGPT and be helped to draft a plaintiff for his personal injury claim, or to draft a defense or an affidavit, then the advantage that previously would have been enjoyed by that law firm on account of its resources is, in a sense, flattened. So there's a sense in which it flattens the legal playing field, especially in contentious matters. Next one, slide 4. And so just to give the examples of judicial decisions on AI use in law. In the UK, just how courts have done it. I've given these 4 cases, basically. The approach has been mixed. It's a careful one, that's what I must say, that they are careful in trying to say, look at the example IEA versus London Borough last year. And it's the pervasive one that we are also seeing in Kenya. Somebody goes to whatever, generates submissions which have hallucination citations, cites laws of another country that do not exist in Kenya, cites a case that does not exist, and because the advocate is not careful, he presents it. The other counsel then checks it, or somehow the court discovers it. And this is what the court said, look, this is irresponsible on the part of the lawyer, if it is discovered, and actually cited these people for contempt and recommended that the Bar Council of New York or of the UK, of England and Wales, to reprimand them and said, look, if you present fake information, it is like unethical conduct of an advocate deliberately misleading the court or misleading the other party for purposes of advantage in litigation. It doesn't matter, and it will not be an excuse that it was generated by AI. You ultimately take responsibility for it. Okay. The same with Elden and Revenue and Customs Commissioners. That is this year. So they again said, look, it's not an excuse for you that these inaccuracies are in skeleton arguments. In fact, in this case, the skeleton arguments were citing a dissenting opinion as the majority opinion. And then this was discovered. And the Commissioner of Revenue and Customs said, the tribunal said, you cannot use this and it will not be an excuse for you. Counsel must check, and the advocate who's doing it is verifying by signing on to those pleadings or onto those submissions that he has checked it. And if he hasn't checked it, then it will be professional misconduct. They then gave some guidelines, basically saying, check this and take responsibility for it. The one on emotional perception AI versus Controller General of Patents. This was an application made using patented information. An application for a patent which was made using neural networks. And as part of the combination, and the acknowledgement was made. And so the Registrar of Patents refused, saying, look, a patent that is not been made by a human being or by a recognizable legal person. So a legal person could be a company, could be a partnership, could be a firm, provided it's registered in law. In this case, part of the patent was made by a contribution of some research that is in that neural network, was not patentable. That part of it, and therefore it did not meet the original thing of an inventive step. It went all the way to the UK Supreme Court, but the Supreme Court said that the AI-based artificial neural networks are patentable, provided there is a technical contribution made by it, but it is not by itself, provided there's another human being who is behind it. So they made this to comport with the European Patent Office. The European Patent Office had previously accepted that those kind of applications are patentable. And then the London Bar, in this case, which is almost similar to Kenya, a mother who used AI to generate documents she filed in court. They said it is understandable that you are a lay person, but citations must be genuine. We will not take any action against you, but citations must be genuine, and it will not save you that they are not genuine. And therefore, again, disregarded. In this case, they didn't regard it, but they disregarded those parts of our submissions where the citations were false or hallucinatory, as we call them. Next slide, please. The US example, there are two. Here, I'm trying to use it to show the risks of it, where a criminal defendant got information from his advocate and then sought legal advice from an AI platform, a publicly available AI platform, in connection with a criminal investigation against him. When this was discovered and the prosecution discovered this, he sought to have this protected from being disclosed to the court. Okay, and his argument was that this is confidential information, which you are entitled to cannot be disclosed to a court in the prosecution. But the court told him, no, you are not an advocate. That kind of information would have worked if you had exchanged it with your advocate. An AI system that is publicly available platform is not an advocate, and therefore communication exchange between you and them is not privileged communication, which ought not to be disclosed to a court. So they found themselves with that coming as evidence, which was incriminatory. So the court told them the privilege did not attach, and that evidence was admitted, and it led to his conviction. Another one was State versus Loomis. Here they used in sentencing, the example Leo gave earlier. It's a risk assessment tool in sentencing. And what is it called? It's a risk assessment tool used in sentencing. COMPAS. It stands for Correctional Offender Management Profiling for Alternative Sanctions. So it's an algorithm that is placed in, and it checks the person. It includes those things as race, his profession, whether he's been held before for a crime, and it generates a sentence. Now, when they challenge this as due process, because they were arguing that this report provided by this system is not one for which the counsel or the defendant could cross-examine its assumptions and the basis of the recommendation. The court held that yes, whereas that might be the case, it ought to be used with caution. It needs to be disclosed that it was used and the influence it had on the sentence, But because it was not the sole determining factor, the defense could not cross-examine. It still held that on the whole, the Supreme Court of Wisconsin held that on the whole, the sentence would be upheld, but warned that, look, this kind of system needs to be applied with caution, and disclosure ought to have been made of the involvement of COMPAS in this thing. The next one. Kenya's courts. The one in example, and the use in Kenya's courts is the two decisions that Leo talked about. But in this case, we've had the one that has been in the public eye is really this one of Nayan Mansuklal versus Commission of Administrative Justice, where two judges made two decisions in the last 2 months, which we need to think about. In one, remember again, this Mr. Nayan Sailor made a complaint in court. He's representing himself. His argument is that he does not wish to take counsel or cannot afford it. And then he made an application by way of notice of motion. A notice of motion is just an application that is made under the supporting affidavit, is the oath to support the facts of it. And in that application, the judge held, when the other counsel opposed it, saying, look, computer-generated documents or outputs of artificial intelligence cannot be a proper substitute for human-drawn documents, and therefore struck out the application, did not even consider it, said, just because they were generated by artificial intelligence, we will not accept it. Incidentally, again, in April this year, it then turned out that a judgment had been given in December, again based on pleadings, which this gentleman had again generated using artificial intelligence. He's a layman, he's just literate, he admitted, but he does not have an advocate. That judgment which he had won, when I was supposed to be expecting compensation to execute it, instead it was set aside by the court. And the court said that because these applications and essentially the petition in this matter had been generated by artificial intelligence, which he had admitted, they could not be accepted. It set aside the judgment and said that the reasons the court gave, this is a curious one for me, that the civil procedure rules, that is that the law do not authorize artificial intelligence generated content, which is true, but it does not buy it either. That was my unease with that decision. Secondly, they were arguing that the use of AI confers unfair advantage on the party using it, therefore undermining the adversarial character of equality of arms within the Kenya legal system. So they sort it out. But I have issues with these two. in terms of the reasoning. So basically, from it, you read the attitude of the courts. And these were two different judges, though in the same case. You read that the attitude of the court would appear to be not even just of caution against artificial intelligence, but one of almost pessimism as to its value, and therefore rejecting them. And I think, in my mind, that this is unfair and would appear to be, takes me now to the next act, which is what recommendations would I make? One, the attitude of the court seems to be like the one of concern for technology. No, let's just go to the next one, of technology. I've mentioned in the last dated conclusion that we seems to be treating the courts, AI, which is just new technology, the same way the world reacted on the Oncomouse patent. I don't know how many of you remember the case of the Oncomouse. Okay, it's a lawyer's thing in intellectual property law. It was a big one in the 80s when Harvard University Medical School researchers discovered a specific gene in the mice that could be mutated to generate to imitate cancer in human beings, and they therefore sought to patent the mouse itself. And it was the first time an organism was being patented. This was before Dolly, before cloning came up. And I think it was the precursor to cloning. It was really, really contentious. Judges were divided left, right, and center. There was whatever. It went all the way to the Supreme Court. And the argument was that, oh, no, this thing it cannot be, this is technology that is wrong. You cannot patent life. It divided opinion. And I think that was the thing, just the dangerous. And the scientists were saying, this is something we've generated from a mouse. Mice don't generally react in this way, replicate reactions to oncology the way the human beings done. We have made it do that, and that's why we are seeking this protection, so that it helps us further our research in developing medication for it. It was contended. Eventually, they were permitted to patent it, and I'm seeing in it a similar reaction that comes from, in my respectful view, a lack of either true unwillingness or just a standoffish attitude that whatever it is, once artificial intelligence is mentioned, we do not wish to deal with it. You cut it off. So in my recommendations, I would suggest, one, we need to remember that AI is a tool, and that first, its use in court cases may have been, I think, depending on where you are technologically. I mean, there are law firms in this country that have had a document processing unit, which essentially analysis, case analysis servers and documentation and generation for years. Even when I started practicing law about 2 decades ago, we had document processing units. And all this work that is now available online was being done except that it was just internal. It was not web-based, but it was within internal systems. So this is not new. The thing is that it is now just a little bit more available publicly. Okay. So it is not entirely new. So I think the courts need to be aware of that. What then we may need to do is that, if necessary, we should consider rules, perhaps. Yes, this is how we go to it. But we should avoid this mechanical legal thinking that if there's no rule about something, it must be excluded. Consider if it is necessary to disclose use of AI in pleadings. So you said, okay, I generated this from AI, and then therefore people can check and make a decision on it, or these citations, the way we do in law when we cite websites. You download it, and then you do a certificate of electronic evidence. You say, I downloaded this on this website as of this particular time on this particular date, if that will help. And then consider allowing use for factual summaries, bench notes, and maybe, but not for legal reasoning. In England, that has been the case. Guidance has been given by the Master of the Rolls for use in summaries. This is for judges. They said, okay, you can use it if you have documents or submissions that are going to hundreds of pages, you can summarize them to maybe 30 or 40 pages or whatever it is you want and use it, but not for legal reasoning. I can live with that. But what we must understand, this fear that it will be, it's generating fake citations, it's generating funny things. At the end of the day, documents that are filed in court or submissions that are made, the person who makes them as an advocate has an ethical responsibility. That is why you see every document filed by an advocate, in fact, it's a requirement of the Advocates Act, must be signed by somebody who has a practicing certificate. If it's a law firm, it must be signed by an advocate within that law firm, which can then be checked. So that person is effectively taking responsibility for it. And we cannot pretend that we are naive to the fact that a good number of documents churned out by lawyers, law firms, and are filed in courts and all those things are generated by people who are non-lawyers themselves. Often students, interns, they do it. Then the advocate looks at it. Sometimes they don't, but he signs it by taking responsibility for that work, for its quality and for its professional and legal compliance. So I think probably this is the approach they should accept and say, look, if documents are filed, whether they are generated by artificial intelligence, automation, or whatever other method, you take responsibility for it. If it turns out to be false, then let the ethical regulations regarding filing of false documents, because even uttering a false document is a crime to a public officer, to a judge, let those laws take effect. There's law already to deal with it. But to then refuse to accept something that is real in the legal profession, I think is retrogressive. And thirdly, their argument that it does not, it's an unfair advantage, I think is not true, because the bulk of the AI resources that people use, the ChatGPTs, Lexus, they have some components which are free, and there are some which are, in my view, they even balance the playing field, particularly in litigation, because then a person with just access to the net can access those and be able to get responses and just file his documents the way he would, whether or not it comes from the equivalent of a Wall Street law firm or the also runs, as we sometimes call law firms, that we consider less distinguished, or that advocates consider less distinguished in with a tongue-in-cheek, or even the solo practitioner or the person who's representing himself. There's a sense in which this availability of AI balances that technological advantage that might come without it being there. And especially since the bulk of it, yes, there's that for which you pay, but there's that which is also available for free, but which is very useful. So that the thing that I would want to understand is that I wonder whether lawyers would be willing to think, would remembering that this thing is a tool just perhaps help the judges take in the breath and be a little bit more receptive to it, might just probably be the case. So that we don't argue form as we seem to be arguing here, because this is something that has been happening. We are arguing form. And secondly, the person who's caught here appears to be just somebody who's not a professional. I am sure advocates have used AI systems or another in court documentation. I have myself used them sometimes when a judge tells you, put this thing in 5 pages. Your submissions come to 11 pages, and you just put it in a system and say, please edit this thing for me into 5 pages without missing its essence, and it generates it for you. So I don't know what he would then make of those submissions if he was to know. So it's a fact. This is already with us. We are resisting something that is not basically a plane that has taken off, something that is already in use. What we may want to think then is, if necessary, have some rules and guidelines around it. Thank you.
Thank you, Seku. That brings us to the end of our presentations. Before I open it up for plenary, we have some overall comments, some discussant comments. So Kwame, you can go ahead.
So two things that are bad. The first is that basically AI is not just generative AI, which is more recent and obviously has the digital component up here to also distinguish AI from obviously general automation and that. But because we are discussing policy here in legal practice generally, but more especially with the judiciary or how the judiciary should view it, I'll do three things. First, I'll talk about, I think, how economists think technologies are adopted in general. And then the second one, I'll talk about some of the things that an economist would consider. And then thirdly, I'll spend about 5 minutes to speak about the fact that, I mean, as I was concluding this, trying to prepare for this meeting, I realized that there's a draft AI policy that's been drawn by the judiciary. I'm trying to make some comments about what I think about it. So first, when new technologies come, and so let's talk about AI, for instance. You can classify its adoption into three. I like the rule of threes. You can talk about people who want to be on the cutting edge, who are the more radical adopters. You can talk about people who are more pragmatic. And in terms of being pragmatic, say, look, we are dealing with a public sector service. It might have unintended consequences for its use in general. And for that reason, we'll adopt a cautious approach. So more or less like putting it in a sandbox and saying, like, look, let's have its utility and its case use justified, and then proceed over time until as much as is possible. So it's a risk-based approach, minimizing risk. And then there's a third one, which is basically, what do they call it? A complete resistance, which is, look, we will ring fence, we'll we'll fence around, and we are not going to allow any. And the examples that Seko and Leo has given us tells us that in Kenya's case, it seems as if it's a mixture of the prudent approach on the one side, and then secondly, the resistance, which is one of the things that we've done. And people who fall on that spectrum between prudence and resistance tend to have a lot of push and pull one with the other. And it generates inconsistency because on one side, the same guy who generated documents. I'm fine. The same side that has one goes back and you create inconsistencies in the legal system. Forget about the jurisprudence stuff, but basically about the practice. I think the other thing that people have a problem with is whether AI is thinking or not. Now, AI as a technology, whichever way, I mean, whether it's generative or other forms that people have in proprietary systems, and it doesn't have to build thousands of lines of code. People can argue, but basically what it is doing is it's ordering information and data. So it takes out input of whatever kind, some of it proprietary, some of it public, and generates out of it content for one way. So it might be in a court and all that, and we've seen all that things. So the first thing that I wanted to say was that it looks as if in Kenya's case, we're in the middle place, which is a cutting, pragmatic, on a case-by-case basis. But then we have other judicial officers receiving pleadings, for instance, that simply throw them out. And the decision for us is the classical problem we have in law, which is if something is not necessarily spelled out, how do you interpret it? Do you interpret it as permissible, or do you interpret it as impermissible? And the impermissible one is completely interesting because it's not just a conservative position, actually. It's a position that assumes that you can always read the future and foretell the future. And obviously, the reality of human life in history tells that that is not a prudent approach. So that's the first thing that I see. Now, if you are an economist, you'd ask yourself, what's the use case for any new technology out there? And you can tell that one of the things that's coming up here, by the way, is that the utility for it is, there's an efficiency thing. It saves time, its ability to do certain things efficiently. That's one. But I think people are placing AI tools on an artificial that, unless it is perfect, outside the risks that come, even when humans write documents or actually make them. We've had the examples that mistakes happen. And that's part of why judicial philosophies exist, to actually screen out the function of especially in an adversarial context, such as Kenya's, is that you are required to plead your case. Whether it's in a criminal case or whether it's in a civil matter, you plead your case and the other side responds, right? In other words, there's a search for the truth. And a search for the truth means it has to be sifted. And my view is, I think it's a cop-out for judicial officers to state that the only reason we would not allow AI use tools is because there might be errors. I'm not too sure that all those thousands of lawyers who appear before courts every day make pleadings that are error-free. So we are trying to hold a tool and its intellectual input, which is not necessarily generated organically, but it's generated from the fact that it's putting together many other things and making a calculation. That's precisely what it's doing. It's doing a statistical calculation. So why that should happen or not, but the efficiency side is possible. And in that efficiency side, it's helping to break sweat by putting a 4,000-page document or helping people to do that. So it will actually do things. So that's one. I think if you come from a background of Kenya where, and my colleagues measure case management and case conclusions, basically resolution, Kenya has a problem. And the judiciary itself admits it. If you see their records every year. So we know that last year they cleared some, it's concluded, resolved close to something like a good number of cases. But at the end of the year, there are even more cases in. In other words, there was an additional number. So if these tools it's self-evident that some of these might help, it might help. So that's from the demand side. So on the supply side, on the demand side, for people who seek justice, we've seen that resistance. The judiciary itself is undergoing automation over time, which allows people to not just automate, send pleadings in one way or the other, to start cases and to track cases and all that management things that are happening. There's no way you're going to go out there without eventually, because you're generating a lot of data and documents in which artificial intelligence will not be useful. Now, whether it's willed or not, some people will start to use it because it's advantageous. So the point I'm trying to make is that it is unlikely that there's a use case doesn't exist. And what the judiciary or judicial policy should be in this instance is about trying to manage those processes in a way that generates the best use cases one way or the other. Will there be wrong things that happen in the end? I think there will be some stuff that will happen. So that's one thing. So the thing is it efficient? What kind of trade-offs is it going to allow us to make? A disclosure policy is also important. And I think one of the things that perhaps is necessary is for those disclosures to be made. Perhaps accept that when documents are filed, that disclosure is one of the things that goes into it. So there are ways for testing those methods and all that. The financial impacts that will come from it, basically, for instance, a cost-benefit analysis. I think that's one thing that the judiciary could consider as well. That lawyers are using it, or lay people are using it, suggests that there's a utility component for it, and there's a use case for it that needs to be considered very, very keenly. Yes, it looks like I'm pleading the case of some of these people, but let's accept that those are real choices that are going to have to be made. Now, I think I should now talk about the document. There's a judicial policy on AI. I don't know whether anybody else has seen it, but I got it is. And the way to assess it is, to what extent is it close to the cutting edge, right? Because we've seen that there are two things. One, there are those who actually, like the Luddites, who say, look, we cannot use this new technology. It's far too risky because we don't understand it. We've seen that in Kenya, there's like stepping on both sides, where in some cases, it's even acceptable by judicial officers who know, and it's applied by the demand side, which is basically the litigants. So let's ask ourselves, what are the policy strengths of the document that has been sent? One of the things that I found very impressive about this the policy on AI, is it has impressive constitutional anchor. In other words, whoever was crafting this policy started with the fact that, fine, we know that lawyers are people of detail, tried to present it in a constitutional grounding. And I think that gives us a very strong legal foundation, which is a good one by putting that. The document is longer than it should be, in my view, to be honest. It could also benefit itself from editing by AI. There's no reason to have a 44-page document. I've seen one from a country that has an 8 one. I think one of the Baltic states has an 8-page, well, maybe 11, because there's a cover and one of that. But I know it in Kenyan culture. When you're drafting a policy, you imagine every single thing and all dots and whatever. So that's the first one. So it goes beyond establishing principles and goes into very, very descriptive detail, but it has strong constitutional grounding, and that is something I give credit for. The second one is recognizing the fact that this is a new quote-unquote technology, or it might have different implications for processes, insight, and outcomes. It requires mandatory testing for judicial officers. It does not require one for lawyers on the other side, and I completely understand that. So it required a mandatory training. Some of my colleagues at the Institute of Economic Affairs recognize the word capacity building. So embedded in this policy, I know it has not been adopted. It's one iteration of the policy, but that requirement for capacity building is essential. The third thing which is also good about it is that clear AI usage rules with that checklist. Impressive as well. So there's structured guidance for daily use by legal officers. And remember, it does not only assume that only judicial officers making decisions. Basically, it recognizes the judiciary as an institution. Impressive as well. And then goes about to talk about structured guidance for daily use, regardless of which part of the hierarchy they fall in. So it might be also for a court clerk or somebody else up there in the registry who would be receiving this kind of stuff. And that's impressive. So there's basically like what they call a 360 approach, a 360 approach. And then the fourth one is basically it considers broader implications beyond what the actual budget for implication will be. And they have a vendor enforcement mechanism, knowing that if AI is accepted, you'll have all others Kenyans, right? Starting to appear there, right? And trying to sell one kind of instrument or the other. 5 years ago, it was selling dashboards, and then there'll be enforcement mechanism against vendors. It also exists in this policy, and that's impressive. And if you look at the appendix, the most impressive first part for me was that the appendix E, particularly because I looked at that keenly, there's a daily use compliance tool. Just rigorous in my view in that way. So whoever that did this, I think we have to give you on that basis of its policy strengths, in my assessment, and again, just as somebody who studies policy, I think they have a 4 out of 5. So basically 8.5 out of 10 things. I'll speak about the things that could be improved, but that's my assessment. What are the policy weaknesses? One is, while they consider and mention the word ethical several times, I didn't count it, but that should have been counted. So there's a consciousness around the ethical uses of this, even within a public sector institution organization such as the judiciary itself, not small, uses a lot of public resources, but also one that has a lot of power with respect to people's liberties and constitutional responsibilities and rights and privileges. There's no public oversight of AI use. For instance, there's no public registry or a transparency mechanism attached to how the judiciary itself would use this as proposed, based on the document, I think it's iteration 3 that I saw. So I think that's one thing that could be considered. And if you did that, you'd be pushing us back towards what I think is perfect. And is it possible to build perfect policy? It is possible to build policy that's so ahead of its time and so useful that it will generate by itself very little process frictions. So that's the first one. I think they need to provide an AI public oversight mechanism, whether it's external or whether it's through disclosure or transparency mechanisms declared at the registry, which is available transparently. The second is there's no opt-out for litigants. Look, we shouldn't assume that every litigant would want it, right? Maybe it is possible, and this is perhaps what could have been, I think Sekou mentioned this as well, but one of the things that you provide a bifurcated process, which means parties that trust are face-to-face judging everything or legal drafting in everything should have access to it, and they should have the option to exercise and request an AI-free process. And those who want an AI model process, model process can also be, so that the real efficiencies of one against the other can actually be demonstrated. And this third one is just a simple beef, but I say every policy requires regular renewal. Now, the renewal cycle here declared in the policy itself is annual. And I'm asking myself whether this is too slow for rapid AI evolution process in which we are. And again, maybe I am spoiled by the fact that we still think of AI itself on the public sector side as generative and all that. They'll take on cycles of their own. And then the final one, bias detection remains a concern. Let me mention why bias detection, and I'll finish here, Jackie. Bias detection remains a concern for me for one reason. There's a study by the LSC who studied the decisions by Kenya's judges over, I think, 3 or 4 years, and they showed a disturbing, consistent, systemic bias, ethnic, because they started by trying to search for biases that are related to gender, and they found the ethnic biases in sitting judges is detectable in their decisions and are concerned. I think one of the tools that AI has, it is not perfect, it's the ability to detect patterns in an objective sense. So maybe those who are considering writing this should input a bias detection mechanism, which could be reviewed whether by a registrar or a committee of or the JSC itself could then review it, and then to do something like that and find it. And then, of course, if you do the opt-out mechanism, you can provide an A/B testing for those who opt in and out and compare what the results of those cases are. That would provide a richer policy reform mechanism. But in the whole, I think this is an impressive one, given the risks that obtain, but also the advantages which they've tried to balance. Kinti, thank you.
All right. So thank you. Thanks a lot to all the speakers today. I think you've had both the economic perspectives, the economic background, the legal perspectives, and the policy dimensions. So with that stated, I think I'll now open it up for plenary because we are out of time, and allow you to ask questions. I do not see any questions in the chat box as yet. So, but I'm sure there must be a few people who have some curious thoughts. So please raise your hand and then I'll allow you to, yes. Beverlyn, I see your hand is already up. Michelle, just as please allow them to, yeah. So Beverlyn, please unmute yourself and let's hear your question.
Thank you. Thank you very much for the insightful presentation on the use of AI within judiciary. I'm wondering whether the policy is sector-wide, because I foresee concerns in other jurisdictions also catching up with us. For instance, discussion within a police sector, whether police can use AI to draft a charge sheet, or also prosecutors can use it even when they are drawing up their reasons on why a person should be granted bail or not. So I think apart from focusing on judiciary, we may want to look at the sector-wide deployment of the AI. Otherwise, we'll just be dealing with one component of justice system and leaving out us. Thank you once again.
Sorry. Yes, thanks, Beverlyn. Let's see if anyone else would like to ask a question so that we can take a few before we allow the speakers to respond. Does anyone else have a question? Or we can start with that then. Okay, so Leo, we can start with I know it was not directly directed at you, but if you have any thoughts, and then I'll come to Seku and Kwame. So Leo, do you have any thoughts?
Yes, and we had featured it as part of the presentation that it could start. There's the bail, there's at the bail stage, and even to consider others. So, for example, at the bail stage, you could be looking at summarizing a police report related to, say, an offender who has gone to the judiciary many times, their previous conduct. So it could be in the entire criminal justice system, subject with the exceptions and riders on how that would be utilized, because the aspect of use is something that, so like for machine learning, it's not prone to errors or those hallucinations, but for generative AI, it is. So it could be used for the entire system. There has been plans in the past, for example, to digitize the OB, to ensure that it's all on a digital platform, so that it allows police reports to be read at not from one location, but from many other locations. But as we understand the political economy issues is that the police want to hold on to the physical book, and which is something that needs to be. So it's a sector, they use the utility, given the fact that it's used not just in the criminal justice system, in the legal system alone, in other places like education, industry, manufacturing, and many other places. This is something that can be used, including the medical field. This is something that can be used in the sector-wide. Thank you.
Okay. Yes. Yeah. Our suggestion is a good one. Yes, it's true, and I would say that most people, at least most organizations, and most people where we are today, probably already have developed AI guidelines, or have contended with its use across all sectors, not just in law. The examples I was giving are examples that I am currently employing. We've done one recently with even company secretarial things, where you now transcribe for you, ChatGPT, all these things. Microsoft has a system, they transcribe for you, they draw out the minutes, draft out the resolutions, and generate a matters arising report within minutes. So basically, it's reduced also the function and the responsibilities of a company secretary. So basically, what I'm suggesting is that as you do a pest analysis, people in business know it about what are the political, the environmental, the social, the technological, and all those other analyses. When it comes to technology, almost every organization, not just businesses, every organization in every sector must begin to think about how AI, one, is going to affect their business, is going to give them an opportunity, and the threats and the opportunities that they could leverage AI to overcome. So I agree with you. The examples Leo is giving, something like drafting of charge sheets, I don't see a problem why it should not be like. Somebody should just fix in the identities, the names, and even the facts, if need be, so that the AI can even decide, look, on the facts that you're giving me, based on the evidence that you have, this is not going to, we're not going to hack it for murder. Let's go to manslaughter straight away, and you charge the lesser offense instead of that. But it's just a question of the willingness of whether it is. But as I say, it's being done everywhere. In journalism, I'm sure you've seen, in our journalism, we've used AI for quite a long time now. We've just recently published AI guidelines for editorial news gathering. So I'm sure almost every industry should do it as a matter of survival, business survival, and even as a matter of continued existence, and even operational efficiencies. In light of those benefits we were talking about, there is something AI will give to everybody, and it's therefore necessary to think about it. So I agree with that comment, that it's important. It's not something anybody can overlook. Thank you.
Yeah, thanks, Seku. And Kwame, finally, let's hear your thoughts.
Well, I think what it stated is the same thing that we started with. Any document generated by AI should be the responsibility of who presents it in a formal space, right? So that's the first. And the second is, today's discussion was about its use in law, in litigation, and in the judiciary. And the judiciary also has its policy, which in my ranking is about 8.5 out of 10. Yes. So what we can do is, after this, basically ask everyone to conduct their own scoping and analysis about to what extent would AI be useful to within a police station or a center of justice such as that, and go ahead to draft it. I will conclude with this. We have to be careful not to catastrophize AI uses, or to go head in the clouds to think that they are a perfect solution for all the other problems. It's just like any other technology, and technology is sometimes value neutral. So with it comes new risks that it helps us to accomplish many other tasks. Thank you.
So I see another hand. Sharon Makoriwa, I'll allow you to unmute yourself and ask your question.
Thanks, Jacqueline, and the rest of the panelists. One of the things that happens quite often with policy development is resultant, unexpected, or unforeseen outcomes. And I base this question on observations that I've had in as a legal practitioner, where clients will often approach you having looked at what the steps are for a certain function using AI, or they review your output. They put it into an AI tool and they review it. And I've noticed two recurrent themes that come out with the use of AI. Is AI is not very good at spotting omissions. So in an output, in a work product, it won't notice if there are certain, it's not very good at picking out if there are certain clauses or input that should have been included that's missing. Two, when they come approaching you, for example, how to do certain processes, say, for example, how to, replace a lost title deed. Yes, they'll get the steps on the internet, but the steps will not give jurisdictional nuances, what truly happens on the ground. And so I put this out to the panelists. I wonder if, say, for example, there was heightened adoption of AI, and so every officer or every person receiving a document within the legal context appreciates that it's sort of, a machine generated output. They will look at it through a machine generated lens. Do the panelists see potentially a gap where in a jurisdiction where, and I feel I have to apologize for this, where, corruption is a running theme? What then is left in terms of nuance and processing?
Okay, thanks, Sharon. So I hope the speakers have had the question. I think it was very clear. On the chat, I see Joanne says, I agree the courts should allow use of AI with attendant rules. That's the future. AI is the future and change is constant. Thank you to the presenters. Then Lillian, is the judiciary policy document available in public domain? Okay. So to begin responding to Sharon's concerns, I'll start with you, Seku.
Yes, Sharon makes a good point. But what Sharon needs to understand, yes, is that we also need to be something that is always there with the nature of the client. That you're always the principal client, but you're the principal advocate. But the client also sometimes thinks he knows some law because he's discussed it with that, and that is the reason why you need to explain to them the Advocates Act requirement that somebody takes responsibility for it. Okay, so you will explain to them that it's not in the same way something like just a bail application. If you read the constitutional principle, it's 2 lines that everybody shall be entitled to bail unless a compelling reason is known. But you know that a bail application is not simply citing that law and saying, okay, give me bail. There's no compelling reason. It goes to more than that. So that's something that has existed. It's just that now AI is a new tool. As advocates, I am sure you've had an instance where a client is challenging you based on the opinion of another advocate, sometimes. Sometimes even challenging you based on the opinion of his daughter or son who's a law student. Or sometimes even on the basis of an opinion given to him by a court clerk. That this and this is what you have to do. So that's something you must be alive to. And the response is why my recommendation is that, where you say, look, at the end of the day, I have to take responsibility for this work that I am doing. And to tell everybody and have everybody even first understand what AI is all about. It just understands, processes information that exists based on what information that is available. So if you make a client understand that and therefore explain to them that at the end of the day, there is still, and that is what we need to do. In fact, I think that's the challenge for the legal profession, which is why we should not shut the doors on it. We should make clients understand that there's still space for an advocate behind every brief. And that there's reason for it. Demonstrate value beyond what somebody can do from desktop research. And it will be difficult, but I think it's a firm and honest and fair conversation to have with a client. And then just let them do, someone else is taking responsibility for it. I am the one on record for you as your advocate, not your daughter or son in third year, or that law clerk who's your neighbor, explaining this and that. This is the reason why I am doing it in this particular way. It's not always a comfortable conversation, but it exists, and it's something we must take up. And I understand what you say. That's a good point, that AI will now be the new co-counsel in this matter. That's why you can see one of the AI tools that I use is called co-counsel, that helps you as advocate. Says, okay, it's sitting in the role as co-counsel, but at the end of the day, you must bear responsibility for the advice you give and the quality of service. So over-reliance on it, just like anything else, can also be risky. That's what I would say.
All right, thanks. We come to Kwame on Lillian's question.
Yes, the copy that I have was sent to me by email, but I think it's available because the judiciary will be placing it out for public participation. So let me find a link. If it's not available somewhere, then I mean, this copy is available for circulation because, yes, I told them that we'd be using it for a conversation today. So Lillian, it can be sent out to you for your comment. Thanks.
Okay, so Lillian, you can share with us your contacts, and then is there any other question? Does anyone else have any burning question as we move towards the end of this session? If you'd like to ask a question, please do so. But as our panelists, as we prepare to wrap up, I also had just 2 questions for each of them, which you can share together with your closing remarks. That's Leo and Seku. So my very brief one for you, Leo, was given what you told us about your framing of AI as an input into judicial production, just from a very practical sense, where would you think Kenya's judiciary would most likely see the highest returns from AI adoption in the short term? So as you summarize, give us your concluding remarks, you can respond to that. And then for Seku, the question that I have at the back of my mind is, so do you see any value in separating the use of AI for the generation of the factual summaries that you've told us about vis-a-vis legal reasoning? Can it be used as a substitute? Should it? Is there value in maintaining the human reasoning, or if the machines are smarter, can we go with that? So where do you think, if at all it should be, where do you think the line should be drawn in practice, especially as we see the AI tools becoming more sophisticated? So please respond to this as well when you'll be giving your closing remarks. And so for the closing remarks bit, I'll start with you, Leo. Please go ahead.
On the area that I think there's big use case would be on the transcription side. So if you look at there are AI technologies now that allow a voice that AI to be trained in that specific on video, on transcribing video, and they can also cross-check for errors, so that the typing process, because typed proceedings is a big question in our legal system, on our legal systems, so that the function of typist or the typing pool would be now to cross-check and be able to review and see that those type proceedings are actually it's a true record of the court. Now, so that's the most important part. And I also wanted to add in closing, another writer to also to Sharon's question. The most important thing that we have to realize is that AI is one thing. As artificial intelligence advances, we are very sure now that AI will not actually be a substitute or replace original human thinking, but it will be an important complement where on the complement an important complement for routine activities and also as a research tool. So, like for example, there is a one thing that that for people to learn is prompting. So if you don't know, for example, like the case Seiko mentioned, like or a specific field, you will not be able to give prompts relevant to that. So you have to, it's a complement, it's like a research tool so that you're able to prompt. So if you ask it specific questions, you have to have some level of expertise to be a very good what people call the prompt engineer. So if you are prompting, you are prompting from a point of reference. So it's something that needs there's a certain level of knowledge that you must have. And that's the most important thing. So it will not replace the original human thinking, but as a research tool, it will be very efficient and very effective, and very effective, and we are seeing those benefits. We are seeing those benefits. Thank you so much. So we are going to, once the policy comes out, but also we are going to look at other issues on that radar related to questions around trust, questions around privacy, questions around given that most of those models are trained in sub-Saharan countries, what does that mean? Labor and many other things, both constitutional, economic, and legal questions related to that. So thank you so much, and expect similar topics around this area. And we want the IEA to be your mainstay for issues related to AI, the law and economics of AI. Thank you so much.
Okay, my closing remarks. Let me answer your question as I close because I won't say much. Whether I see any value on that attempt at distinction that it be used only for case summaries, etc., but not for legal reasoning. Perhaps I need to say that makes sense only with regard to the judiciary. This was a guideline given by Lord Voss, the master of the rolls, for judges to use it. And the reason why it is limited to not being used for legal reasoning, because you see, a judge makes a decision based on the evidence and the submission between him. So basically, he's being told, do not use a reason that was not cited before you and which both parties have not had a bite at that cherry. Okay, so I can get it with it being told that don't bring a new reason that the parties did not raise, because it will be unfair to the side that finds itself on the opposite, because they were not given an opportunity to respond to it. But as advocates, we do use it where you say, look at this case and give me alternative reasoning as to how I can do this on these facts. So in that sense, it makes sense to me. I see the value in judges being told, do not use it for legal reasoning, because of the issue that the legal reasoning was not before you. So it's like raising evidence or arguments that the parties did not make before you and which you did not get the benefit of both sides of submissions on. So in that sense, I agree. But in conclusion, let's remember the big thing that I want us to do is just to remember, in whatever sector we want to use it, that artificial intelligence, and I will use this, is simply an enabler. It is a tool. It can help in refining results. It will not be the result in itself. So what then people need to do is in determining what processes do I want to use it for and what can I not use it for. And that's why, as Leo says, it is something for which, as every tool, just like every tool, you can say a mechanical saw is a tool, and you need to develop expertise on how to use it. Just like a knife, just like an axe. We will also need to use AI. It's not going to be the solution to everyone for everything. There are those who are going to be better placed to use it. It's just that it's now a little bit more available to most people. So even then, as he rightly says, how you prompt it presupposes already a certain level of knowledge and a certain level of evaluation and analysis that you're then asking is to do. So for me, I would, in the legal profession, suggest the guidelines I have is that this is a sounding board for us. That's why you say you generate your submissions first, and then you ask it to grade it for you. And if it grades you well, you go with it. If it grades you poorly, you use it to improve. You say, okay, in what sense then can we improve this? That's how it's, at least we use it here for our journalism, and that's how I've decided to be using it for the legal thing. But to take it as an end in all will lead to the situations where there will be mistakes. And then just like a tool, it could be a hammer for you. It's not going to be the solution for all the problems you will have or all the challenges that you must come. It will also come with its own challenges on how to deal with. And so that's what I would suggest. But just to accept it and to suggest again, the next thing, remembering it's a tool, approach it with pragmatism. That's it. Thank you.
Thank you. Thanks, Seku. Kwame, I don't know if you have any closing remarks, final thoughts. Thank you to our speakers for those very rich and insightful presentations. I hope you've all learned something. But in summary or in conclusion, I think the common finding or the emerging finding is that the ethical use of AI is mostly must remain within how we balance the efficiency with fairness, and those technological capabilities with the constitutional principles. So they've reiterated here that we must, AI, we must approach its use as a tool and not as a substitute for judicial reasoning. So we will continue these conversations. And as Leo has mentioned, the presentations will be available online in a couple of minutes after this session. So if you'd like further engagement, please, you can download it. Then thank you also for all of you who are here for your contributions to the discussion. And please look out for other IEA sessions and webinars like this going forward.